your appearance on this content. May I proceed, Your Worship? Your Worship, Ms. McCarthy appears on behalf of the accused. The matters on the roll today for further investigations, Your Worship. Your Worship, at this stage, the ballistic report remains outstanding as well as a few statements. In light of those circumstances, state will request a postponement to the 29th of April for further investigations and as well as for the legal representative of Ms. McCarthy.
Mr. Maponya, sir, the matter is demanded for further investigations as well as for your lawyer, Ms. Mukabe, to be exposed. On the 29th of April, you are on to be back at 8:30. Your bail is extended, sir. Failure to appear or other fathers in the office. Please call me to complete this investigation in your matter.
Ramaponya, October 29, that April, like that first April. Lebaka la gore molato o busetse morago ka jeko moeledi wa gago gayo
The matter is on the roll for judgment on sentence. Today, in the 1st of April 2022, the matter of Bathabile Dlamini, case number 410102021. Appearances are as on the previous occasion.
As a copy, Your Worship, I just want to express our regret that we could not accommodate this court yesterday. We really wanted to, but it was not possible. Thank you.
There's nothing that necessitates shall proceed with the sentencing. Following the court sentencing. Number one, please authoritative work and punishment. Johannes Kokenis, intellectual observation, wrote his father 100 years ago that the end of punishment, therefore, is no other than to prevent the criminal from doing injury to society and to prevent others from committing the like offense. Such punishment, therefore, and such mode of inflicting them ought to be chosen as will make the strongest and most lasting impression on the minds of would-be offenders with the least torment to the body of the offender. C.R. versus Swanepoel, 1935A at 454. 2. The traditional objectives of punishment are distribution, prevention of crimes, and the deterrence of offenders, as well as the possibility of rehabilitation of the offender. Voted with approval in S. versus Nkambule, 1993-1, in bracket A, 136 and 145 to 146, as the ends of criminal justice. 3. The process of seeking effective sentence through balancing of relevant interests and factors was aptly and famously summarized by Judge of Appeal E. Ram, as he was then in S. versus Z, 1969, bracket 2 SA 537, in bracket 8 at 540328, that is the crime, the offender, the interest of society, and in S. versus Conga, 1993-1 SA 365 in bracket B at 369D, Chief Judge Detroit then stated that a sentence is only effective when it strikes a fine balance between the interests of society and of the offender. If it brings about retribution, but of a balanced nature, it deters moderately, individually, as well as collectively or generally. It makes provision for the person and the unique characteristics of the offender seeking to rehabilitate or at least to improve him. It was further emphasized that there rests a duty on the court to harmonize and balance the three aforementioned factors, that they are to be considered in conjunction with one another. In S. Mrs. Banda and another 1994 2 SACR 352 X 355A to C, the court stated the elements of the tried factors contain an equilibrium and attention. The court should, when determining sentence, strive to accomplish and arrive at a judicious counterbalance between these elements in order to ensure that one element is not unduly accentuated at the expense and to the exclusion of the others. Therefore, it is imperative for this court to consider the tried factors as was originally articulated and indicated above here in paragraph 3. Furthermore, in S versus B 1972 3 SA 611 in bracket A at 614 D to E, Judge of Appeal Rome stated punishment should fit the criminal as well as the crime, be fair to society, and be blended with a measure of mercy, according to the circumstances. Element of mercy, though a hallmark of civilized and enlightened society, when it comes to administration of justice, my emphasis should not be overlooked, lest the court be in danger of reducing itself to the plane of the criminal. And true mercy has nothing in common with soft weakness or morbid sympathy for the criminal or permissive tolerance. See also X versus Sparks, Stater 18, delivered on the 18th May 1972. I have considered accused's personal circumstances as was placed on record that she is 59 years old, of age, single parent with 2 dependents, former Minister of Department of Social Development, currently earning approximately 40,000 per month, plus 70,000 stipends she receives as a president of the ANC Women's League for a current term ending in June 2022, unless the said position is further renewed. Her financial responsibilities in supporting herself and dependents towards the family, she submitted that she did not benefit from the offense or from her transgressions. She requested the court to consider granting a fine instead of a direct imprisonment. The defense argued that if the community expected the sentence to be harsh, then the legislature would have prescribed that it should have done it as it did in other serious cases. However, the legislature was content that such an offense should be at the level of the district court, and therefore that the sentence should be commensurate with those in the district court. I further considered the state's submission that accuser's position at the time of the commission of the offense must be taken into account, the offense which reflects a character of dishonesty, whereas the office she occupied at the time demanded a high standard of honesty and accountability, that she was in charge of the department which was responsible for the majority of our ordinary citizens in dire situations having to face uncertainty regarding their social grants, that giving of false evidence or making false statements made under oath does tend to critically and severely affect the moral precincts of our society and impede administration of justice, that such conduct should not be tolerated or easily condoned from any member of society, that the community expects to see justice being done by punishing such conduct, and that the law shouldn't be seen to distinguish when it comes to protecting and or when punishing the diverse members of our society, that the perception that the rich or the leading members of our society
gets away with injustice should be done away with. That respectable members of our society who hold high and authoritative positions of power should not get away with dishonesty, but must take responsibility and remain accountable. That therefore the effect of sentence should be sensed as far away as Cape Town in Parliament to the Union buildings in Pretoria and by the ordinary and downtrodden members of our society. The state argued that direct imprisonment was not far-fetched in this case. However, that should the court be of a different view, a hefty fine to be considered. In Mudau versus the state, case number 9764/12 ZA SCA 56 delivered 9 May 2013, a paragraph 13, Judge of Appeal Masjid set out the approach to sentence as follows. It is equally important to remind ourselves that sentencing should always be considered and passed dispassionately, objectively, and upon a careful consideration of all relevant factors. Public sentiments cannot be ignored, but it can never be permitted to replace the careful judgment and fine balancing that is involved at arriving at an appropriate sentence. Courts must therefore always strive to arrive at a sentence which is just and fair to both the victim and the perpetrator. Have regard to the nature of the crime and take account of the interests of society. And as was put by Judge of Appeal Corbett in S versus Rabi 1975-4 FA at 855 in bracket A, 866 A to C, that sentencing involves a high degree of responsibility, which should be carried out with equanimity, and that a judicial officer should not approach punishment in a spirit of anger, because being human, that will make it difficult for him to achieve that delicate balance between the crime, the criminal, and the interest of society, which task and object of punishment demands of him or her, in bracket. Nor should he strive after severity, not on the other hand surrender himself to misplaced pity, whilst not flinching from firmness where firmness is called for. He should approach his task with a human and compassionate understanding of human frailties and pressures of society which contribute to criminality. The offense committed by the accused is a serious offense, warranting retribution, and the sentence to be imposed should not only deter her but also general would-be offenders. It must have the effect of rehabilitating her as well as reforming her. She is still an active member of our society and plays a very influential role at that, and therefore also looked upon as a role model by others. During her tenure as a former minister in the Department of Social Development, millions of social grant beneficiaries looked up to her for their grants. As a former public office bearer, from the onset, her case attracted a lot of public interest due to its background and because of being an important figure in the community. Currently, the president of the NC Women's League, I'm also not blind to the visible support she's been receiving from her party and possibly her family members since the inception of the matter. She has a previous conviction committed more than 10 years ago. However, in terms of Section 271, capital A of the Criminal Procedure Act 51 of 1977, the said previous conviction does not qualify to be expunged, nor has accused otherwise provided this court with any certificate of expungement in terms of the said act. It goes without saying that the accused's previous conviction and the current offense both have an element of dishonesty or misrepresentation. Thus, it cannot therefore be completely disregarded. However, the court does appreciate that 15 years have lapsed since then and that she did make it to be a minister 7 years thereafter despite that previous conviction. Nevertheless, the society is exacerbated by the commission of the offense of this nature by a former government official whom greater level of responsibility and accountability was expected and still is. Others, however, may misunderstand the crime of perjury as a light offense with no consequences. It is, however, vividly clear in this court's mind that the consequences of accused's conduct, which has led to her current conviction, were dire, that it had involved overstepping a role and authority which brought about the fiasco of SASSA, causing unnecessary anxiety of majority of vulnerable members of society who were grants beneficiaries. And when the Constitutional Court was at pains to seek clarity from her, instead of being upfront, she withheld information from the said court for fear of exposure being maladapted into legal court, which led to taxpayers' money being utilized for Section 38 inquiry in terms of Superior Courts Act 10 of 2013. That was conducted by the Honorable Judge Mwepe. Furthermore, the department's taxpayers' money being used for free legal fees to get her out of the quagmire she put herself in the first place, not playing open cards. Therefore, the misunderstanding that the crime of perjury is not a serious offense is incorrect. Thus, the argument by the defense that she never benefited from her transgressions cannot be far from the truth. Hence, the society looks upon the court for its protection under such situations. The court further considers as aggravating the fact that accused, prior to occupying her office as a minister, she took an oath of Section 95 of the Constitutional Act 108 of 1996 as a minister then, to be faithful and obedient to the Republic and to the Constitution while executing her duties. The country is aggrieved and disappointed as accused's conduct for not fulfilling that obligation which was embedded upon her. She has not shown any remorse despite her conduct having caused serious impediment to the administration of justice, and for wasting not only taxpayers' money, but the time as well, which took to unravel all these. This court further considers that due to accuser's failure to take the Constitutional Court into her confidence, was in 2018 ordered by the said court to personally pay 20% of the legal cost of the cases pertaining to the SASSA debacle. It was humbly requested for this court to take that into account as a mitigating factor. Further, that at this stage she is not only standing before the court as a former minister, but that she stands as a pensioner. Thus, having tried to balance all the aspects and purposes of sentence, the accused's personal circumstances, the interests of society, and the seriousness of the offense she committed, without overemphasizing one element over the other, and without overlooking any of these factors, I have also considered various sentencing options. However, due to accuser's age, background, and the nature of the offense, I have found some not suitable and will not therefore burden this judgment at this stage. Safe to say that the parties had proposed a fine as well as a custodial sentence, as is apparent from the submissions above herein. It is right law that the court ought to strike a balance in relation to the tried factors and to equally apply the traditional elements of sentencing as are indicated above. In exercising its judicial discretion in imposing an appropriate sentence, the court ought to have a firm hand, whilst at the same time balance some with a measure of mercy. Section 92, subsection 1 of the Magistrate Courts Act 32 of 1944 as amended, read with section 89 sub 1 and sub 2, provides that, save as otherwise in this act, or any other law specifically provided, that the court, whenever it may punish a person for an offense by imprisonment for a period not exceeding 3 years, where the court is not the court of the regional court, or not exceeding 15 years where the court is the court of a regional division. B, by a fine, may impose a fine not exceeding the amount determined by the minister from time to time by the notice in the Gazette for the respective courts referred to in paragraph A. And Section 1, Sub 1A of the Adjustment of Fines Act 101 of 1991, in bracket A of AOFA, provides that if any law provides that any person on conviction of an offense may be sentenced to pay a fine, the maximum amount of which is not prescribed, or in the alternative to undergo prescribed minimum period of imprisonment, and there is no indication to the contrary, the amount of the maximum fine which may be imposed shall, subject to subsection 4 of the Act, be an amount which in relation to the third period of imprisonment is in the same ratio as the ratio between the amount of the fine which the Minister of Justice may from time to time determine in terms of Section 92, Sub 1, Sub B of the Magistrates Court Act 32 of 1944 as amended, and the period of imprisonment is determined in Section 92, Sub 1, Sub A of the said Act, where the court is not a court of a regional division. B, for the purposes of paragraph A, a fine as well as an imprisonment may be imposed. The Government Gazette Notice 217 dated 27 March 2014, that is Government Gazette 37477 in bracket, provided an amount of 120,000 where the court is not a court of a regional division, and 600,000 where the court is the court of a regional division. In the Western Cape review judgment by the Honorable Judge Tulari, acting judge as he was then, in the case of the State and Graham Thomas Raymond Hemel, case number 171172-2017, delivered on 8 December 2017. The judge stated in relation to the computation of fines aligned with the period of imprisonment, in paragraph 12 thereof, that a sentence is in the discretion of the magistrate. However, the discretion does not enable courts to impose the sentences which are more severe than the sentence which the magistrate was competent to impose. More so, where the severity is founded on drastic and unexplained departure from the principles and rules which includes statutory rules of calculation and computation, close quote. Whereas in the same province in 2019, in the case of the State versus Zane Grenier, case number 19113, delivered on the 3rd of October 2019 by both the Honorable Judge Bokwana and Acting Judge Tulare as he was then, where at paragraph 6 thereof they made reference to S versus Pamal 2018 in bracket 2 SACR 206 in bracket WCC. The court held that computation ought to be applied rigidly in each case when the magistrate decides to impose a fine, thus losing the particular circumstances of an individual case. Paragraph 8. The court stated that to an extent that Pamal conveyed that a formula ought to be applied every time a judicial officer decides to impose a fine. My underlining here in that interpretation is not correct, as it is not consonant with the cardinal principle established that sentence must be individualized and must fit the particular accused, the nature of the crime, and the interest of society. Although Pamal did retain the residual discretion at paragraph 12 of the judgment and emphasized that a judicial officer ought not to impose a sentence that is disproportionate for purpose of clarity, where a fine would be considered of which payment must be enforced by a term of imprisonment. Such sentence of imprisonment for any period must be within the limits of the jurisdiction of the court or extended jurisdiction as prescribed by any law which would be applicable. Paragraph 9, also my underlining here, emphasize that uniform term of imprisonment as an alternative should not necessarily follow particular fine that the magistrate has determined, vice versa, and mechanically. A sentence to be imposed is within the discretion of the trial court. In S. versus Swart, in bracket 181072, close bracket 2018, ZAWC HC, delivered 13 November 2018. The court there stated that sentencing entails the exercise of a discretion vested in a court which, like all discretionary powers, must be exercised judicially, and as expressed by Judge of Appeal Mokumi in Songo Supra, it must be exercised judiciously and in accordance with the principles of fairness and justice. At paragraph 10 by the two justices, again Bokwana and Tulari, they stated that although no formula should be followed, fines should be consistent so as to create certainty, depending on the circumstance of each offender, the seriousness of the crime, and the interest of society. Paragraph 11 states that it is established that the magistrate is not obliged to apply the ratio and must consider all relevant factors in order to meet justice as the circumstance of the case dictates. When it comes to the relationship between a fine and a period of imprisonment, it is impossible to generalize. The particular and material facts and circumstances of the case are relevant considerations. They accordingly agreed, the two justices, with the dicta set out in various cases like S versus 1 1992 SA and 877 at 897 and 879. S versus Kapeng 1992 in bracket 1 SACR 596 and S versus Hayes 2001 in bracket 1 SACR 545 in bracket SC at 546A to B. Finally, at paragraph 12, that proportionality is a key consideration in sentencing. While the relationship between the fine and the period of imprisonment may be relevant for determination, regard must be had to the crime, the criminal, and the interests of society. Finally, I did take into account, most importantly, accusers' financial means and potential thereof. Considering a person of a caliber, it is therefore this court's view that after all consideration, the following sentence is appropriate, fair under the circumstances. You may rise at the stage, ma'am. The accused is accordingly sentenced to a fine of 200,000 or 4 years imprisonment. Half of the sentence is suspended for a period of 5 years on condition that accused is not convicted of the offense of perjury and Section 38 of the Superior Court Act 10 of 2013. No order is made in terms of Section 103(1) of the Firearms Control Act 60 of 2000. And ma'am, in terms of Section 309B of the Criminal Procedure Act 51 of 1977, you have the right to appeal against this court's conviction as well as sentence. However, you need to file a leave to appeal to this court either today or within the 14 days period from this judgment. Thank you.
I have not consulted with my learned friend in that regard, but I think the prosecution would not have an objection. Thank you for the enlightenment. I've taken instruction. The indication from Mrs. Dlamini that she will be able to pay the 20% of the unsuspended portion, which will be 20,000 rands today. So that order would be appropriate.
Is that as far as you can go, sir?
I beg your pardon, Your
Is
Worship.
that as far as you can go, because that's what just a submission. Is that as far as she can go, sir?
Yes, that is as far as she can go. I understood the state to be saying 20%, if I'm correct.
It's a submission, sir.
Yes, I'm saying,
Still maintain my discretion.
I know that,
Besides, still on the matter.
I know that, Your Worship.
And I know the defense hasn't addressed me regarding the other aspects, but I'm sure the defense is interested to get my ruling regarding that.
The 20%, yes. The rest, the deferment of 100% of the payment, yes.
So my point is, the entire sentence is not concluded. That half of the portion.
Oh.
Any submissions along those lines?
I don't follow, Your Worship.
Any comments, Sage? Any comments on the submissions?
On the submissions, Your Worship, we don't have anything further.
Another reason why this court took time to deliver sentence was also to enable the defense an opportunity to gather itself. And it was even from the defense's submission that the defense would opt to pay a fine in the systems. I should have thought that the defense had prepared better than what I'm hearing today. But nevertheless, the sentence is already tendered, and the state is not objecting to the request to defer the payment of the fine. Therefore, it shall be so. Accused will then have to pay 20,000 today, and the rest to be payable not later than the 29th of April 2022. It was fairly late, and there will be unpleasant consequences if we all do not come to that. But then that concludes the case for today.
As the court pleases. May we be excused, Your Worship?
I just find out the situation now, what happens to the accused in the meantime?
That was very expert. When Mr. Bathabile is concerned, the state is asking what then to happen to the accused presumption.
The accused will remain in court, or if the court is going to rise, I'm not sure when it's rises, but it will be attended immediately. But we request that should not be taken to the cells. It's not necessary.
What the state was saying is that the sentence has been passed now, and there is an option of a default, which they are asking for. But in the meantime, then the future will remain in the state. That's basically what the state is saying. Because nothing has changed. The court has not changed the sentence as well. The sentence stays as is.
That's what I was trying to get at. It's earlier on, but I guess I was defense did not catch up. But I will wait for your response.
Your Worship, the issue of the 20% attended immediately. We appreciate that at this point, before payment of the fine, the accused is in custody. But we will arrange with the investigating officer or whoever that she remains available and not be taken away to the cells, because it won't be necessary, if that is what the prosecution is referring to. But the payment of the fine will be attended to immediately. If the court had other cases, it would have happened before the court arose.
So I mentioned that in the application also.
Yes, Your Worship.
Accused to remain
On warning up until,
or anything to that aspect.
that is our request, that she remains on warning as she has been. After conviction.
Nothing further. We haven't had any discussion. We have already made a submission.
So is the defense asking the accused today must go home? That is the defense, what the defense is asking.
That the accused?
That the accused must go home today.
Today, yes, that is what we.
But then the defense needs to be clear, articulate that clearly, that this is not the defense's application. Because not the entire sentence is paid today, it is deferred and it's not yet even paid. So the defense is asking that
The accused be released on warning up until, on condition that the fine is paid as ordered.
And what if the effect of default is not materialized then on the 29th of April?
The law will have to the law will have to apply, and we know the consequences, Your Worship.
Proceeding from the amenable resistance to the next warning until the entire fine is paid by the 29th of April 2022, failing which then immediately the law will take its effect.
As the court pleases.
You are all excused. Thank you.
I should take out the